The Motor Vehicles Act 1988. So this is a very important concept of third unit. The first question in this is claim tribunals. What is composition of claim tribunals and its powers and functions has been asked as a long answer. So the composition of claim tribunals is mentioned under section 165 of the Motor Vehicles Act 1988. So what is its composition? State government establishes, so it is established by state government, one or more claim tribunals for claims in accidents causing death, injury, loss of property to third party by person driving motor vehicle. So this claim tribunal is established by state government, and they may establish one or may establish more than one claim tribunals in a state. So for what purpose it is established? It is established for claims in accidents. So if the person who is driving the vehicle or the person injured has insurance, they may claim their insurance from this claim tribunal. So for claims in accidents causing death, injury, so if a person who is driving the vehicle has insurance and he has caused death or injury or loss of property to third party, and so he may claim the victim from that owner of the vehicle, he may take his insurance and claim that insurance from this claim tribunal. It consists member state government may think fit. So the claim tribunal may consist as many members as the state government may think fit. There is no limit, minimum limit. If there are more than one member, then chairman is made. So if the claim tribunal consists more than one member, the state government appoints a chairman among them. Qualifications for to be a member of claim tribunal. The qualifications are: he must have been a judge of a high court, so he must have been employed as a judge of a high court, or he must have been employed as a district judge, or he must be qualified enough to be appointed as a district judge or a high court. So these are the qualifications to be a member of claim tribunal. The next is, if two or more tribunals are there, then the state government distributes business among them. So if the state government establishes more than one tribunal, then the state government distributes business among them. Powers and functions. So the powers and functions of claim tribunal are mentioned under section 169. So the section 169 says that the power of claim tribunals is to hold inquiry for giving award under 168, may follow any summary procedure it thinks fit. So if it is giving award under 168, if it is giving claim, then it may hold an inquiry or any procedure for the inquiry it may think fit. The next power is all the powers of civil court, such as taking evidence on oath, enforcing attendance of witness, and production of documents and material objects in conferred upon claim tribunal. So all the powers of a civil court are conferred upon claim tribunal. It acts as a civil court while exercising its powers. Then for inquiry, they may choose any person having special knowledge of matter to assist in inquiry. So if they want to conduct an inquiry before giving award, then they may choose or hire any person they want who is having special knowledge of that matter to assist them in inquiry. So this is the first question. The next question is compulsory insurance of motor vehicle. So this is a very important question and has been asked for many times for long as a long question. So compulsory insurance of motor vehicle. In India, according to Motor Vehicle Act 1988, motor vehicle insurance or at least third party liability motor insurance is compulsory. So according to this act, Motor Vehicle Act 1988, the taking of insurance by any vehicle owner is compulsory. So section 158 of the Motor Vehicle Act 1988 says that it is compulsory to produce certificate of insurance who is driving in a public when asked by a police officer in uniform. So if you are driving your motor vehicle in public And if any police officer in uniform asks you to produce a certificate of insurance, then it is compulsory for you to produce a certificate of insurance. The person can produce within 7 days. So it is not necessary that you give it him that day itself. You may produce that insurance copy within 7 days. Then section 159 says that state government makes rules making necessary to produce a certificate of insurance for authority of use of a vehicle in public. So the state government makes the rules. They make it necessary to produce certificate of insurance if you are driving vehicle in public to authority. Regarding this, the state government makes rules. The next is section 146. No person should use vehicle in public place without insurance. So if you don't have insurance, then you cannot drive your vehicle in public place. If you want to drive your vehicle in public place, then it is mandatory on you to have insurance. And when a police officer asks you to produce insurance, it is mandatory upon you to show him insurance. Then section 147 says that insurance must be provided by an authorized insurance. So the insurance you have must be provided by an authorized insurance, and it must cover the damages of death and injury and damage to property of third party. So these three subject matter it should cover: death, injury, and damage to property of third party. This much it should the insurance should cover. So this is the compulsory insurance of motor vehicle. The next question is compensation is in the Motor Vehicle Act 1988. So there are many compensation. So when is the compensation awarded to victim? In section 161, hit and run. Section 161 says about hit and run. So what is hit and run? Hit and run means when the identity or whereof of the accident vehicle is unknown. The vehicle through which the accident is done, the identity of that vehicle or the whereabouts of that vehicle, the location of that vehicle currently is unknown, then it is called as hit and run case. Compensation by General Insurance Corporation to person suffered grievous hurt or death by hit and run accident. So the General Insurance Corporation, which we have studied in previous unit, in the second unit, will provide compensation to any person who has suffered grievous hurt or death by hit and run accident. So the identity of the person who has done accident here is unknown, so you cannot claim insurance from him. So that is why GIC, the General Insurance Corporation, provides compensation to victim. It is without insurance. So only to those person who has suffered grievous hurt or death by hit and run, the General Insurance Corporation provides compensation. For death, if the accident, the hit and run accident has caused death, then the compensation is 25,000 rupees. And if the hit and run accident has caused grievous hurt to the victim, then the compensation is 12,500 rupees. Refund of compensation, section 162. So when is victim liable to return the compensation to insurer, to the compensator? If already received compensation, insured should return compensation to insurer. So if by any other mean the victim has already received compensation, then he must return his compensation to the General Insurance Corporation. Section 163A, compensation of structural formula basis, and section 140, no fault liability. So there are two kinds of compensation. The one we saw, 163A, is General Insurance Corporation giving the one is section 163A, compensation of structural formula basis, and the next one is section 140, no fault liability. So in both section 163A and section 140, the owner of the vehicle pays compensation here. In section 161, we saw that the General Insurance Corporation was paying compensation. But in section 163 and section 140, the owner of the vehicle pays compensation. So in section 163A, owner of the vehicle pay to legal as a compensation on death or permanent disablement. So if the owner of the vehicle, if he has caused death or permanent disablement through his vehicle, then he is liable to pay compensation to the heirs of the victim. And negligence or wrongful act of owner doesn't matter. So if the owner, it doesn't matter if the owner of the vehicle has caused the accident by negligence or by due to his wrongful act or anything. If he has caused the death or permanent disablement, then it is compulsory for him to pay compensation. Negligence or a wrongful act of victim doesn't matter. So then in the starting 2 points are of section 163A. The starting 2 points are also included in section 140, but section 140 continues that negligence or a wrongful act of victim doesn't matter. So if the victim, if he has due to his negligence or wrongful act, he suffered the death or permanent disablement in accident, it doesn't matter. Even if he was negligent, the owner of the vehicle must compensate. For death, the compensation is 50,000 rupees, and for permanent disablement, the compensation is 25,000 rupees. Procedure for compensation. It is mentioned under section 141 of the Motor Vehicle Act. So, right to claim compensation is in addition to the right on principle of fault compensation. So, as we saw, there are two kinds of compensation here. One is under section 163A, the another one is section 140. So, under section 140, the compensation is directly mentioned. For death, 50,000 rupees, and for permanent disablement, 25,000 rupees. But in section 163A, the compensation amount is not mentioned. So if you want to claim compensation in the 163A, you will have to file a suit. And the court will decide how much you have to pay, how much the compensation the owner of the vehicle will have to pay. So the right to claim compensation is in addition to right on principle of fault of compensation. The next is claim in section 140 should be completed efficiently and should be disposed in first place. So if the claim is made under section 140 no fault liability, then it should be completed efficiently and should be disposed in first place. So there are two compensation, as I said, section 140 no fault liability, where the compensation is directly mentioned. For death is 50,000 rupees, and for permanent disablement it is 25,000 rupees. And the next is right on principle of fault, which is section 163A. So if the compensation of section 140 is less than the section 163A, liable to pay extra. So in section 140 we have 50,000 for death and 25,000 for permanent disablement. But under 163A, the court decides to give him more compensation, then he will have to pay extra amount. Addition to this, 50,000 and 25,000. And if compensation of section 140 equal or greater than section 163A, then not liable to pay. So if the court also says the same 50,000 and 25,000, then he is not liable to pay extra amount. So this concludes the Motor Vehicle Act 1988. There are in total 4 questions, and one question is fixed in this. Thanks for watching.